हेलो एंड गुड मॉर्निंग एवरीवन। आई होप यू आर डूइंग गुड एंड आप सभी की ड्यू LLB की प्रिपरेशन बहुत अच्छी चल रही होगी। गाइज, आई हैव स्टार्टेड अ सीरीज ऑन द लीगल स्टैटिक GK वेयर वी सोल्व द पास्ट 10-year questions of the DU LLB, and this is the part second. Part first is already available on my channel. The link is in the description box. And this is the part second where we will cover the past 10-year questions of the legal static GK through MCQs. And I have also put the handout of the same on my Telegram channel. The link is in the description box. You just have to check it out. And before we start the video, if you came to the channel first time, I suggest you to subscribe to the channel and hit the bell icon so that you won't miss any of our future videos. So with this, now let us start with our first question. Question number 1 says that you purchased a mobile phone handset which stopped working in its guarantee period. Alright, so underline guarantee period. Then the mobile handset manufacturer is refusing, again underline refusing, to repair or replace the same. What would you do to get a justice quickly? Underline the word quickly. It is important for us. So it is simply saying that you buy a phone and it is in the guarantee period and the manufacturer is refusing to replace or repair it. Now what will you do to get a quick justice? Alright, so there are options available. You are having 4 options available before you, and remember it is saying quickly. I am emphasizing more on the word quickly. It simply means that there may be more than one remedy available before a customer. Alright, so it means that you can go to this, but you have to tell which is the quickest way to get the justice. Now the options are A, B, C, D as this. Option number A says that approach the civil court with a suit of declaration. Option number B, file a writ petition before the High Court. Option number C, approach the Consumer Dispute Redressal Forum. And D, make a complaint of chatting before the local police station. And the right answer to this question is option number C, that is that you have to go to the Consumer Dispute Redressal Forum to get justice quickly. Now coming on to question number 2. Question number 2 says that how many places of sitting the National Green Tribunal has, and it is the latest question of 2021, and the right answer to this question is option number D, that is 5. That means to say that the NGT, that is the National Green Tribunal, has its branches to the 5 places. This is the one form in which they can ask you the question. Another form on which they can ask you the question is like this. They can ask you the name of the 5 places where the NGT is having its branch. So they may ask you the name of the 5 branches, and it is in the New Delhi. So the first form in which they would ask you the question is like they have asked in this particular question that they have asked you the number of places where NGT is having the branches. The answer is 5. Another way in which they can ask you the question is the places. Like you should know the 5 places where NGT is having its sittings, right? New Delhi, Pune, Bhopal, Chennai, Kolkata. These are the 5 cities where NGT is having its branch. In New Delhi, it's a principal branch, alright, and other branches are in these 4 cities. And this is the another way, like they would give you the question like in which of the following place NGT is not having the branch, and they will give you the option like New Delhi, Pune, Ahmedabad and Bhopal. So you have to mark Ahmedabad because in Ahmedabad there is no branch of NGT. Alright, so they may give you questions like that. Another form in which they would ask you the question is the state wise. They may ask you the state, like which of the following state in which of the following state there is no NGT branch, like Maharashtra, like Uttar Pradesh, like Madhya Pradesh or Tamil Nadu. You have to mark Uttar Pradesh because in Uttar Pradesh there is no branch of NGT. So city wise, state wise, it is a principal branch. Alright, so this is how you have to cover, and exactly I emphasize more. Why do I emphasize on the previous year question paper? This is the reason why, because with this particular question you are not solving that particular question but all the possible questions which may formed with that particular question. So this is the ideal way to solve the past year question papers, where you exactly solve all the probable questions from that particular question. So I hope you got my answer. So with this, now coming on to question number 3. Question number 3 says that which of the following is not a feature of the criminal justice system in India? And it is emphasizing that not. It simply means that out of 4 there are 3 options which are feature of Indian criminal justice system. So innocent until proven guilty, it is a very important feature of the Indian judicial system, that you will be considered as innocent until you will be proven guilty. Then the right against self incrimination, it simply means that nobody can force you to give the give the witnesses against yourself. Nobody can force you to get statement against yourself, and it is enshrined in the fundamental right in article. Now this is your homework, and you have to tell me in the comment box that right against self incrimination is the fundamental right which is given under article. Alright, if you know the answer, just mention it in the comment box. This option number C is the preponderance of probability. It simply means that the degree of certainty of belief that convenience that the existence of fact is more probable than its non-existence. Alright, preponderance of probability simply means that the court will get the probability, like okay, this may happen, possibility, probability. And you know that in Indian criminal system there is a very lesser place given to the probability. Alright, so this is not the feature of the Indian constitution, sorry, the criminal justice system. So option number C is the right one, and the D is that proof beyond reasonable doubt. It is a feature of the justice system that you have to prove the question beyond the reasonable doubt. So option number C is the right answer. Question number 4 is the what is extradition treaty? So the right answer is option number A, that is it is a treaty for surrender of an alleged or convicted criminal by one nation to the another. Alright, for example, if one nation has to give their a person who is basically convicted for any criminal offense, so they may give it to the another country if they have signed an extradition treaty. For example, Vijay Mallya, Neerav Modi, we know that these guys are in the foreign countries. So if India have signed an extradition treaty with these countries, so they can surrender these convict to India. So that is called as extradition treaty. Now coming on to question number 5. Question number 5 says that the trade practice known as minimum resale price maintenance is prohibited by. So there is a trade practice which is like minimum resale price maintenance, and this is prohibited by Monopolies and Restrictive Trade Practice Act 1969. So these kind of questions are somehow asked. These are tough questions, very tough. So ऐसे questions वो पूछते रहते हैं, like 2021 में भी एक ऐसा ही question आया था. These are tough questions. Now coming on to question number 6. Question number 6 is that which of the following laws does not entitle a parent to get maintenance? So it simply means that a parent can get a maintenance. Alright, parents also get maintenance from their child. Now they have given us the options, and we have to tell which do not provide. So the right answer to this question is option number B, that is the Guardian and Wards Act does not provide any clause to give maintenance to the parent. And you know that people are basically confused in the CRPC, like कि CRPC में नहीं होता, but no, in CRPC there is a provision where the parent is entitled to get maintenance from their child. So option number B is the right answer to this question. Then coming on to question number 7. Question number 7 says that which of the following is an inchoate crime? And it is very important, like which is inchoate crime. So it is basically those crimes in which there is a chain of which are incomplete crime. These are basically incomplete crime. Alright, incomplete crime are what? Inchoate crime. So criminal attempt, Criminal attempt is this crime because it is incomplete in its nature. It is just mere an attempt. It is not an actual offense. Alright. So option number D. For example, like planning something. What is attempt? Attempt is like you have attempted. For example, attempt to murder. I have attempt a person to murder, but have I actually done that? No. If I would have actually done that, it will be definitely a full-fledged offense under section 302. So attempt is incomplete. It is mere an attempt. It is not a complete offense. So it is called as inchoate crime. Alright. It is very important and a good question. A very high level question is this. Now coming on to question number 8. Question number 8 simply says that criminal procedure falls under which of the following list of the Indian Constitution? And this is the 2021, and it was basically a question which I can put in the Indian polity or the constitution part, but I thought it is important, so I put it into the legal static GK, and the right answer to this question is concurrent list. So option number C is the right answer. Now coming on to question number 9. Question number 9 says that in criminal proceedings, acquittal refers to. You know that in criminal proceeding there is a word acquittal, there is a word convict. Alright, there is a word acquittal and there is one another word that is convict. कन्विक्ट का मतलब जब उसका क्राइम प्रूफ हो चुका है एंड कोर्ट ने एक सेंटेंस पास कर दिया कि इसको इतने साल की सजा होगी. सो डेट इज़ कन्विक्शन. व्हाट इज़ एक्विटल मीन्स? Acquittal means being cleared of all the charges of accusation. It is called as acquittal. आपने एक शब्द सुना होगा हिंदी मूवीज़ के अंदर कि बाइज्जत बरी कर देना, ठीक है, कि ये कोर्ट इस व्यक्ति को बाइज्जत बरी करता है. That is what acquittal. With all the respect, the court is basically cleared you from all the charges which are framed by the police against you. So option number A is the right answer. Now coming on to the question number 10, that is the last question of the today's video. Question number 10 says that who was appointed by the NDA government as the chairperson of the National Commission to review the working of the Constitution of India. You know that there is a commission, National Commission, which is basically to review the Constitution of India, like how our Constitution so far has worked in our Indian context. So it is a commission which analyzes its working, and you have to tell the chairperson. And you know what is the right answer? The right answer is option number C. That is Justice M.N. Venkatacharya, and he is the 25th. He was the 25th CJI. Alright. He was the 25th CJI of India, and he was the chairperson of the National Commission to review the working of the Constitution of India. So with this we have completed the 10 questions in our today's video, and with that we have completed part second. There will be 8 more parts in this particular topic. So if you watch our this quiz completely, that means that you would be completed more than 100 questions relating to static legal GK, which are sufficient for the examination point of view. So if you like our video, if you like our content, then make sure you like the video, make sure you subscribe to the channel and hit the bell icon. And guys, मिलते हैं नेक्स्ट वीडियो में. जब तक के लिए टाटा बाय बाय, थैंक यू, टेक केयर, शाइनिंग ऑफ.